getting on to YouTube Live takes a minute. I'm assuming there she is. Welcome to the 186th District Court. Court is in session. This is cause number, actually it's cause numbers, plural, 2017 CR 4902 and 2017 CR 9995. State of Texas versus Douglas Shields. We're here in each case for a second amended motion to enter adjudication of guilt. We're conducting this hearing via video conference using the Zoom application. We're also using YouTube to live stream the proceedings to keep the hearing public. Time now is 1:50 p.m. on the 29th day of June, 2021. These proceedings are official. They're on the record and they're being recorded by the official court recorder. Counsel and all present are instructed to act as though you are in court, and all are instructed not to record the proceedings. If I could have the attorneys make appearances, starting with the state of Texas, please.
Austin Stout for the state.
Roger Pettis for Mr. Shields, Your Honor.
Sir, are you the same Douglas Shields, sir, 2017 CR 4902? All right.
Yes, sir.
Do you know how to turn your microphone off and on?
No, I don't.
All right, we'll manage then. But are you the same Mr. Douglas Shields who was placed on deferred adjudication on December 13th, 2017 for possession of a controlled substance 1 to 4 grams? Is that you?
Yes, sir.
And then it's the same date and same type of offense for 2017 CR 9995. You as well.
Yes, sir.
All right. Do we have an agreement?
Yes, sir.
State, what's the agreement?
The agreement on both cases, Your Honor, is to grant the state's motion to sentence the defendant to 3 years in the Texas Department of Criminal Justice with credit for all time served in jail, as well as at safety. The state is going to take into consideration unindicted case in Night Mag 597302. And we've also agreed to recommend a judgment satisfied in County Court Clause 653002, a misdemeanor DWI.
What kind of offense is the Night Mag case, the unindicted case?
It's a possession of a controlled substance, penalty group 1, from 4 grams to 200 grams, a second-degree felony.
All right, Mr. Pettis, is that your understanding of the agreement?
It is, Your Honor.
And then Mr. Shields, is that your understanding of the agreement as well? You'll have to turn your microphone back on, sir. Do you know how to do that?
Yes, sir. Can you hear me?
Yes, sir. Now, Mr. Shields, if I agree to this, I ask that you waive your right to appeal. Do you understand that?
I agree.
But you understand that's what I'm asking you to do, to waive your right to appeal if I agree to this?
Yes, sir. I waive my right.
When you say waive your right, you're talking about your right to appeal?
My right to appeal.
Okay. And Mr. Pettis, any objections to that?
No objections, Your Honor.
All right, Mr. Shields, I'm going to show you a document in each case using the share screen function. It's called the defendant's consent to appear by video conference. Is this your electronic signature here on this document?
Yes, sir.
This is 2017 CR 4902. I'm going to switch over to 2017 CR 9995. Same thing, defendant's consent to appear by video conference. Is this your electronic signature?
Correct, sir.
By signing, let me get out of share screen. By signing those 2 documents, you're telling me you understand that normally we do this type of hearing live and in court, but that you're consenting to do it by video conference. Did you understand that when you signed it?
Yes, sir.
For each case?
Yes, sir. Each case.
All right. I approve that consent. I make it a part of the record. I'm now going to show you in each case using share screen the document that brought you in here. It's called the second amended motion to enter adjudication of guilt. This is in 2017 CR 4902. I'll scroll through because it's 2 pages. I'm going to turn your mic off again. I'm going to scroll through because it's 2 pages. Now I'm showing you the motion, the second amended motion in 2017 CR 9995. Again, I'm scrolling through because it's 2 pages. Are you familiar with these 2 documents, sir? You'll turn on your mic again. You know how to turn on your mic? You did it just a second ago. There you go.
Yes, sir, I agree.
Are you familiar with these two documents, sir?
Yes, sir.
Did you go over these with your attorney?
Yes, I did.
You understand them?
Yes, sir.
Mr. Pettis, do we waive reading of the motions?
We do, Your Honor.
I'm going to get out of share screen. Mr. Shields, to the allegations listed on those motions that you violated community supervision, how do you plead? True or not true?
True.
Is that for each motion, sir?
Yes, sir.
Do you understand, just by pleading true, I can find out those violations are true and revoke your community supervision?
Yes, sir.
Do you still wish to plead true?
Yes, I do.
I find that the violations are true for each motion, and each motion is granted, and in each case you're revoked, sir. I also find you guilty of the underlying offense in each case. Mr. Pettis, is there any legal reason as to why your client cannot be sentenced today?
No, Your Honor.
Being no legal reason, in accordance with the state, sir, in each case, I sentence you to 3 years in the Texas Department of Criminal Justice, and I'll give you credit for time served. I'll also take in consideration an unindicted offense. It's under Night Mag 597302. It's possession of a controlled substance, penalty group 1 from 4 to 200 grams. The way I can dismiss that, sir, is if you tell me that that allegation is true, then I dismiss those cases. And so if you could turn your mic off, back on and tell me that's true, then I'll dismiss that case. Do you understand how we're going?
Those are true.
All right, those are dismissed. All right, or that one case is dismissed from each case. All right, sir, in each case, this is a revocation of your community supervision where you have waived your right to appeal. I'm making a certification of this for the record. I'll provide a copy of that certification to your attorney to provide to you. And is there anything else from either side in regards to the motion or the sentencing in either case?
Nothing from the state.
Nothing from the defendant, Your Honor.
All right, Mr. Shields, good luck to you. What I'm going to do is conclude this hearing. And when I do, I'll go ahead and also end the meeting for you so that they can get you back up to your pod and get you some lunch. There'll be nothing else from either side.